Please come to your order and accept P3. That is the initial order.
A2, my lord.
Order issuing notice.
Yes, my lord.
When it was passed.
It was passed on 16/4/2024.
Please come to the judgment passed by the trial court.
Yes, my lord.
When it was passed.
The judgment was passed on 13/3/2024.
समझ में आ गया क्वेश्चन मेरा? नहीं आया तो मैं समझाऊं. आपके ट्रायल कोर्ट के इसकी जजमेंट के बाद का नोटिस है ये. A3.
No, my lord. That is.
Why saying no?
No, my lord. That is. But I had produced the last order.
I don't know, sir. Whatever you have produced, that I'm. Mister, please don't raise your voice. You have not filed the documents.
But I filed them.
Yes, you have not filed the documents. Whatever documents you have filed, I'm looking at those documents. That is all.
But this is the last.
Final, Mr. Counsel, please bear with me. If you have chosen not to file the document, then don't shout at me.
I'm not shouting. I'm sorry, my lord, if my voice has risen.
Now, once you have relied upon a document which is dated 22/3/2024, and by that order, the notices have been issued, and that order is subsequent to the judgment passed by the trial court under 138 of Negotiable Instruments Act. It is your mistake if you have committed, if not place all the documents on record.
May I clarify this issue?
Right, sir.
Page 28.
I am not supposed to read in between the lines.
Not reading, but I am very specific on affidavit.
I am not going to consider any affidavit when the documents are there with you.
Document is there in appeal, my lord. My lord, may kindly.
Forget about that.
My lord, may kindly bear for a moment, my lord, for a moment. If my lord can bear for.
अच्छी बात है सर, बताइए.
Page 28, my lord. The appeal which has been filed in which this order has been passed. If my lord would see the ground of appeal, the first paragraph, my lord, at page 28. The first, my lord. The appellant being a guarantor of Shri Gita Textile who has committed a default in non-payment of so-and-so section company petition number so-and-so, wherein as per section 96 interim order starts from the date of filing qua personal guarantor, that is with effect from 14/10/2022. As effective on the date of impugned order dated 13/3/2024 and is still in operation as on the date of filing of the appeal memo. I had produced that to show that it is still pending. I mean, these documents are very and I had already the judgment itself says that I had produced the document of initiation of insolvency before the trial court itself, before the London Judicial Magistrate itself. So there is no dispute, my lord, that my moratorium under 96 starts from the date that is 14/10/2022. It is the admitted position. Therefore, my lords, I had produced this order only for the purpose that it is still.
Sir, in which paragraph it has been held by Supreme Court in the case of Mohan Raj that after the initiation of proceedings under the IBC Act,
My lord,
the 138 proceedings will not be maintainable, and you cannot be punished for the check issued by you.
my lord, I would certainly.
Please point it out.
If my lord would come to first passatum, I would have brought down the paragraphs also, my lord. The first passatum just below, my lord, what has been held by the Honorable Supreme Court has been written. If my lord would permit, I would read from there first, and then we'll bring that part of the judgment. Held. Gravamen of a proceeding under section 138 NI Act, though couched in language making the act complaint of an offence, is really in order to get back through a summary proceeding, the amount contained in the dishonored check together with interest and cost, expeditiously and cheaply. Thus, a quasi-criminal proceeding such as that is contained in chapter 17 NI Act would, given the object and context of section 14 IBC, amount to proceedings within the meaning of section 14(1)(a), the moratorium therefore attaching to such proceeding. Thus, the legal impediment contained in section 14 would make it impossible for such proceeding to continue or to be instituted against the corporator itself. Therefore, for the period of moratorium, no 138, 141 NI Act proceeding can continue or to be continued against the corporator because of the section 14 bar, so and so forth. And section 53 of the IB code, that is for the company, that is CIRP, Corporate Insolvency Resolution Process. It says, that the company would be given a new slate. All the matters pending as on the date of approval of the resolution plan would be deemed to be closed.
जी सर. जी sir. This judgment is by
Justice Nariman, Justice Sinha, and Justice
Is there any judgment contrary to it?
No, my lord. As on date, my lord, I had, since I can submitted bar, my lords, that there is no on this count, my lords. On the contrary, I would be, therefore I was
It would have been better for you to say that you have not searched out for any contrary.
my lords, kindly.
It would have been better for you to say. Don't make a statement at the bar.
May I make a submission addition to it, my lords?
There is a contrary judgment by 3 judges bench passed in 2023.
My lords, may kindly consider, my lord. This is a judgment on section 14 of moratorium. That's what my say is, my lord. This is on.
Yes, that is also a judgment on the same lines of the same bench. And you have made a specific submission that there is no judgment.
To the best of my, I did.
It would have been better for you to make a statement that, sir, you have not, or you could not lay down your hands.
Therefore, I had.
There is a specific judgment against you, and in that case, P. Mohan Raj was considered.
I wouldn't have managed since.
That is the difficulty. You people don't make researches and then start arguing the cases. अरे it was beyond reconciliation कि भाई वो सब बंद कर दो उठा के